Yes.
So she makes one point where you could say that's a very important point.
In fact,
because if you said, hold on, if you said, as for prima facie, there are no hard and fast rules about it. Like Dr. Pumpuni said, I can determine the way I want to do it. I can decide that I'll just write one sentence or one line and say a prima facie case has been made. But she says that some of the allegations against her, some of her peers, the judges sitting on the committee, were on the panel of those cases, or they have dealt with some of those cases. So let them recuse themselves, reconstitute this committee. That's why I dissolved the committee, because Justice Puaman, Justice Adibu, they have dealt with some of the cases. What if somebody wants to call some of them as witnesses? And in fact, one of them has indicated that if he's given the opportunity, he will call one of them as a witness. Imagine that the chairman of the panel is being called a witness. Is this not some place we can all agree that it's a fair point she's making in the court?
But
let's hear him. I'll come to you.
Okay.
Now, it may be a fair point if it's demonstrated that it will have some prejudicial implications for the outcome. But the standards for that has been set long ago in Salah versus AG, number 2. So that was edge on the court. Now, this prima facie determination debate is a principle or the law that confers as in Act 30 in criminal prosecution. The prosecutor, when a complaint comes, the prosecutor doesn't straight go to court. It's mandated in law to make a prima facie determination. Then he will charge. No standard was provided as to how that should be determined. Then this found its way in the Constitution. This was a provision that was hardly used until within the past 10 years or so. Now, the debate has been whether or not some guidelines should be provided. So, Adechum clearly has the decision provided some guideline. Now, the concern of the CJ for me is it's a concern that I think can be dealt with when she's giving her testimony. Why?
For the committee.
Because you have been provided with a copy of the petition to respond to, and you did. And after that, a prima facie determination was made. So all the matters that you responded to within the gamut of all the petitions are now in your bosom. You have answered the issues one after the other in your response. Notwithstanding, the decision has been made that a committee should be instituted for you to come and speak to the matters. So, if I were her, I'll just carry the response I gave before the prima facie determination.
Go to the committee.
And deal with it before the committee. If there's a need for me to provide further and weightier materials to support my objection to the petition being heard on its merits, I will do.
What I know is that often the main petition and then the response that is brought, they form the basis of the committee's hearing.
Good. So that becomes, like in parliamentary language, that becomes the travaux préparatoires, that becomes the basic documents the committee will deal with. So I'll be prepared on all the matters that are contained in any of the petitions adequately. Indeed, if there's a need for me to provide further information, like I said, you always ask for an adjournment. Or you prepare in such a way that during cross-examination of your accusers, you put those matters across. Okay. The other issue, which for me falls within Order 20 Rule 9 of CI 47, is the content of the affidavit that the court...
Supplementary.
Yes.
So in actual fact, let's let our audiences know that affidavit is as if it doesn't exist. because it doesn't form part of any process in the court.
It took a judicial process for that to be hacked.
Okay.
So the contents were vexatious and scandalous. So the court thought that we can't proceed with this.
No, that's not the reason. They breach the in camera requirement.
Article 1468.
That's why it was.
That was what the court based on its decision.
Yeah, because you have attended an in camera process, which nobody is supposed to know, but you have brought information from the in camera to the court.
But you see, under CIA 4728, contents of an affidavit, you can, as somebody deposing to you, can actually speak to a matter when it is a matter of fact. So there I would disagree with the court. My problems with the affidavit was rather it was vexatious. Some of the matters were simply not necessary to confront the court.
Which one?
Like saying that the walls around the place was high security. I mean, what has this got to do with they were not necessary.
It's a statement of fact.
Yes, but
you just said that she can allude to statement of fact.
I'm saying that Bet 9 will tell you that these are vexatious. You don't come to court with this matter.
Vexatious?
Yes.
How can that be vexatious?
When a proceedings is held in a premises, in a secured premises.
Wait until you find yourself hold up in a very high wall.
But Castle is a presidential. It's an annex to the presidency.
Oh, really?
Yes, but it is. Not really. These are matters of state.
And the Chief Justice has been hauled before a facility like that?
But there has been the president who sat in the castle and governed this country for nearly 20 years. Hold on.
These proceedings actually could have taken place at the Jubilee House.
Good. But I'm saying. No, but hold on.
What you are saying?
Hold on.
Do you remember where the Ayawaso were gone? Ayawaso West were gone. Hearings were held. That's where it was held.
But that one is a public thing.
Okay.
What do you mean a public thing?
Yeah, but the room. But everybody processes situations differently.
And there were people,
she's feeling a trauma. She's feeling certain trauma over this process. A lawyer is not being allowed and all of that.
Very restricted facility.
Okay, quickly.
Restricted.
The point was made that all previous proceedings were superintended by the CJs. So they found the judicial court premises convenient. Do you know how people fear to enter court premises? Do you? You have no idea. You are a trained lawyer, so you take it whimsically. You take it for granted. There's some heavy sense of trepidation when people are entering court premises. But they were gone there. Now, Justice Derry and co, they were not even giving copies of their petitions. They even went to court to ask for it. They were not giving. Prima facie determinations were made. They went to court. They tried to injunct it. They were in court over 80 times. It never happened. So this Article 146 issues, we can all sit down and say that we can look at it. But by all means, that is the provision in the Constitution for dealing with this matter.
Right.
The CJ herself had mandate under law to discipline other lower court judges. She recently disciplined a Jessica Circuit Court judge. Why? Somebody brought a petition on grounds of misconduct and abuse of power. What did she do? She referred it to the disciplinary committee of the Judicial Council. They went into the matter. They made adverse recommendations against the judge. Based on that, she, as the head of the Judicial Council, with the legal architecture available, she fired the judge. The judge went to court to challenge it, though. But the CJ exercised their powers.
All right.